Hello, I'm Steve Bruce, editor of BLR's HR Daily Advisor. I'd like to welcome you to the first edition of BLR's HR Compliance News Update, our new video series that will keep you up to date on the latest HR compliance news. In each episode, we'll go over recent significant developments and provide insights beyond the headlines from our team of HR legal editors. In the past week, we've had three particularly interesting developments that have implications for employers. These include an immigration reform proposal from a bipartisan group of senators, an appeals court ruling on President Obama's recess appointments to the National Labor Relations Board, and the release of some telling statistics regarding union membership in the United States. Today, I'm joined by Patricia Traynor, BLR's Senior Managing Editor of Human Resources, who is here to provide some details about these developments and to give us some insights about what they mean for employers. Patricia, welcome.
Thanks, Steve.
Tell us about this immigration reform proposal.
Sure. Well, after the election, the Republicans realized that they had really lost the Latino vote. So we're at a point politically where both Republicans and Democrats are ready or enthusiastic about immigration reform. And just this week, a bipartisan panel of senators issued a framework for an immigration reform proposal. And there's four basic areas within this framework. One of them is to provide a path to citizenship for workers who are already here, even though they might currently not be legally here in the United States. And this would be contingent on a couple of things, such as securing our borders. The next thing is reforming the immigration system itself so that it recognizes characteristics that are important to our economy in terms of admitting people into the United States. And then a third pillar, or a third element of the framework, is creating an effective employment verification system. And then finally improving the process for admitting workers so that our workforce needs are served, but workers who are here are also protected. So the proposal is still in very, very general terms, but for employers, it is promising a better verification system and tougher enforcement of the ban on hiring illegal workers. In addition, it mentions a more flexible system for admitting new workers. This is really just a very early step in the immigration reform process. BLR editors are following it very closely, however, and will be reporting as legislation is drafted and debated, and certainly will be keeping employers aware of any changes in their ability to hire foreign workers and in the verification process as they have new hires come in. So we may see some very significant changes, but undoubtedly there'll be a lot of debate before we have a final product.
So we'll stay tuned.
Exactly.
Now, we've been talking a lot about the newly aggressive NLRB, but now it seems a court is questioning the legitimacy of the recess appointments that President Obama made.
That's true. The United States Court of Appeals for the District of Columbia ruled that President Obama did not have the constitutional authority to make recess appointments to the NLRB last year. And what happened was the Senate was not confirming Obama's appointees. So while the Senate was on a 20-day holiday recess, Obama nominated three NLRB board members. The Republicans objected to that, saying that the Senate was not in recess because during that 20-day holiday break, every few days they held brief pro forma sessions and gavelled into session. So the issue was, were they legitimate recess appointments under the Constitution? The district court agreed with those Republican senators and said that the Senate was not in recess, as that's meant in the Constitution. A majority of the judges on the panel also agreed that the vacancies on the board did not happen during the recess. So that further bolstered the view that Obama made these appointments in an unconstitutional manner. So what does this mean for employers? Well, the NLRB has stated that it's going to continue doing business as usual. It'll be issuing rulings, it'll be considering cases, and it's also important for employers to remember that the ruling doesn't affect quite a bit of the matters that the board deals with. So unfair labor practice charges can still be filed. Administrative law judges can still hear cases. And those areas aren't really affected by this ruling. But if employers have a case pending before the board, they really should consult with their attorneys as soon as possible to see what's the best advice in terms of how to proceed with their particular matters. Also, employers should be aware that the Supreme Court will likely end up with this issue to consider. This may take over a year before we get a ruling from the Supreme Court, but if that Court of Appeals ruling is upheld, all of the decisions the NLRB has made over the past year will be invalidated. In addition to that, the board will probably be effectively shut down until we have valid appointments made. So as this goes on and developments occur, we'll be following this very closely, particularly to keep employers up to date on the status of those NLRB rulings that have occurred over the past year and any further appeals that take place in this case.
Thanks, Patricia. And finally, there's been some interesting news about union membership.
That's right, Steve. Just last week, the Bureau of Labor Statistics reported that union membership rates fell from 11.8% to 11.3% in the past year. And these numbers are really a pretty steep decline over just a one-year period, but they do reflect or continue to reflect what's been a trend in declining union membership. So to put this in context, in 1983, union membership rate was somewhere around 20%. But in the 1950s, it was up around the mid-30s, around 35%. So there has been a steady decline in the union membership rate. One interesting piece of information from the most recent data is that older workers make up more of the union membership than younger workers. In fact, workers ages 55 to 64 have the highest rate of union membership, and younger workers have the lowest rate. So we may see a further decline as these older workers retire and are no longer in the workforce. The data can also reflect a changing economy. Construction and manufacturing tend to be more unionized than other areas, and these areas aren't as big in the economy as they once were when the union rate was relatively high. But we've also seen that more states have passed right-to-work legislation and limited the rights of public employers to unionize. So these are all probably factors contributing to this decline. Now, some commentators view these numbers as a sign that, at least in the private sector, unions are becoming irrelevant. But my own view is that employers shouldn't become complacent about unions. The unions certainly have a friend in the White House at this point in time, and organized labor is well aware of these numbers and the trends in declining unionization. And they'll be working very, very hard to turn these trends around.
Great. Patricia, thanks for joining us today.
Sure.
To be notified when future installments of BLR's HR Compliance News Update become available, subscribe to our YouTube channel at www.youtube.com/BLRinc. Thank you for joining us today. This is Steve Bruce for BLR.